Good morning from Waco, Texas. Good morning. Good morning. Well, afternoon now. Okay. All right. Hey, y'all. Thank you. My little Texas accent. I know, right? I'm so country. Hello, Latanya Martin. Hello from St. Louis, Missouri. Good to see you. Hello from Salt Lake City. Hello from Jacksonville, North Carolina. Jamaica. Kenya, oh my gosh, you all are everywhere. I am so glad that you all tuned in today. So I'll go ahead and get into it. My name is Vonda Bailey. As you all know, my show, Support Court with Judge Vonda B. I wanted to make sure that I'm at least engaging you all, not just through entertainment, but through education as well. So that's why this is very important and near and dear to my heart. I'm big on education. Anyone who knows me, they will tell you if you're an educator, I absolutely love you because without educators, we definitely would not be able to do a lot of things in this world. I wouldn't even be sitting here in front of you giving you this information as an attorney if it were not for teachers. So I'm big on education. Before we get started, I just wanted to make sure that I say this out loud and you all, there's no misconceptions or anything. This is only applicable to Texas law. Okay. I practice law in the state of Texas, so that's all that these sessions are going to consist of. Now, every now and then we will go live. I'll just hang out with you all. We may grab a cup of coffee, grab a mimosa, maybe, who knows? And, just talk to each other, have a conversation, just dialogue that way. But these sessions in particular are only applicable to Texas law. This is not legal advice. So if you are tuning in from all the jurisdictions, like I see St. Louis and everything like that, if you have any questions about anything that I discuss here and you want to know if it pertains to your jurisdiction, I highly recommend you consult with an attorney who is within your jurisdiction, okay? So we're going to go ahead and get started. A lot of people have asked me questions about conservatorship, possession, and access. What do these things even mean? I personally believe, okay, somebody from Dallas, Texas in the building, how you doing? I personally believe that before you all can jump right into how much a person should pay in child support, um, what type of credits they're going to be given for child support. Can you take this person to court? You first have to understand your court order. And I see a lot of people not really understanding what their court order means. So let's jump right into it. When you talk about conservatorship, nobody really knows what that means. That's like, okay, it's foreign, right? So essentially, conservatorship, there's a presumption. So when a child is born and it's a suit, it's known as a SAPSCR, a suit affecting the parent-child relationship, SAPCR. That's what that stands for. When there are two parents and child or children, it is a presumption and it is a rebuttable presumption that it is in the best interest of those children to be named joint managing conservators. Well, what does joint managing conservatorship actually look like, right? Joint managing conservatorship means that both parents, not one, not mom, both parents, okay? And obviously we are now we're after the what's called the Obergefell case. So parents also includes two women. It can also include two men, same-sex couples, okay? Two parents, both parents have equal rights to the child. Usually you will see one parent have two rights that are superior to the other parent. That's where you'll see one parent has the right to receive child support and one parent has the right to determine the primary residence of the child. That word primary is so misused in Texas courts by parents, and it's not to your fault, right? You don't really have the basic understanding of what that word really means. It's only talking about the primary residence. Point blank, if you are a joint managing conservator, you have equal rights to your child. You have equal rights to participate in their school activities. You have equal rights to speak to their teachers. You have rights to attend their educational functions, their extracurricular functions, attend doctor's appointments, speak to the doctors about the child, discipline them, teach them any type of religion as you may. You have equal rights to that other parent. You all follow me there? The reason I said it is rebuttable because there are a few situations that will not allow parents to be joint managing conservators. What are some of those examples? Well, the first example is a history of domestic violence. Now, let's talk about that for a moment. Domestic violence is not simply violence between one or both parents, right? Domestic violence can include the child as well. Domestic violence can include a situation with someone other than a parent, but it's taking place in front of the child. It may cause harm to the child. If domestic violence has been found to have occurred 2 years prior to the parties coming into a case, guess what? It is presumed that joint managing conservatorship is not in the best interest of the child. That's one way, right? Another way is sexual abuse. Was that child created from a rape? Was that child created from a situation that involves sexual abuse over and over again to the parent? Has that child themselves been sexually abused? Has that child been abused and the other parent knew that it occurred? Those type of situations can put you in circumstances where joint managing conservatorship is not in the best interest of the child. So when that happens, that presumption then shifts to sole managing conservatorship. Well, what is sole managing conservatorship? Sole managing conservatorship means that that parent who the domestic violence may be occurred to, or they may be in possession of the child and sexual abuse has occurred, that parent is going to have the exclusive rights to make decisions as it pertains to their child. Now, it's not to be confused with that parent being able to be informed about certain things. You still have to let them know a lot of times what's going on with the child in school, their health. They still have the right to be listed as an emergency contact and those type of things. They just may not have the right to determine the primary residence. They may not have the right to apply and receive and hold on to the child's passports, those types of things. So I wanted to make sure that you all understood what that meant because it happens so often where people come in my office and they have a situation where they're saying, I want sole custody. And to me, that's sole managing conservatorship, right? But they don't have the facts to kind of support why they are entitled to that sole managing conservatorship. So when you don't have the facts, it automatically defaults back down to joint managing conservators. Everybody good on that? If you have any questions, make sure that you are putting your questions in the comments because as soon as I wrap up my portion and giving you all the legal side of this, then I will address any questions that you may have that's related to what it is that I'm saying. The next thing I would like to go over is an agreed parenting plan. There are a number of people that say, hey, we got this agreement notarized, we both signed it, we want this to be a legal document. Is that possible? Yes, it is possible. Courts encourage parents to co-parent through situations. They encourage familiar relationships. So they want a child to be able to have access to mom, to dad, to grandmother, to grandfather, to aunts, uncles, everything like that. They encourage that. So agreements are always going to be in the best interest of the child. Why? If you agree to it, 9 times out of 10, you're more likely to follow it, right? If it's something that a judge said is going to happen, one or both of you may be displeased with that and you wouldn't want to follow it. So I definitely understand, the rationale behind courts wanting to make sure that they accept parenting plans. Now, what I will say about parenting plans, when you do go to court to make this parenting plan a legal contract, because as long as you all sign it and notarize it, it's not considered legal in terms of enforcement. Meaning that if something goes wrong and one or both parents are violating the terms of that, you want to be able to take it to court and say, hey, judge, he or she is infringing on my rights. I need to file a motion for enforcement. Or contact the police and say, hey, I have this court order. I need you to come make a record of it so I can make sure that I have it for court purposes or something like that. In order for that to take place where it's enforceable, it has to have a judge's signature affixed to it. Okay. So, because of that, you do have to go in court and prove this up to a judge. Prove up is another word for finalize. So, you want a judge to sign it. You have to keep in mind, although this is you all's agreement, your agreement cannot violate public policy. Okay. Your agreement cannot be illegal. Your agreement cannot be one that is not in the best interest of the child. Because if it is, the judge doesn't necessarily say, I'm not going to sign that. What they encourage the parents to do is to whatever part that possibly violates public policy or not in the best interest of the child, they ask the parents to go back and provide a revised version of their parenting plan. Because again, this is an agreement, so the court doesn't want to overstep its boundaries and tell the parents how they need to parent their child or their children. Makes sense? So, when we're talking about conservatorship, possession, and access, there are a number of things that go into that, guys. Texas law just changed September the 1st of 2021. Huge change. Before I get to that change, I do want to let you know this. There were a number of certain there was a possession and access schedule that existed prior to September 1st, 2021, where the non-custodial parent got their child like on the first, third, and fifth weekend. Some of you may be familiar with that, right? We don't have that anymore, right? Let me say you have it, but it's been modified slightly. So this new schedule, I just want you to know, in Texas, we do have certain schedules for children under 3. So the schedule that I'm getting ready to tell you about that has been modified, it doesn't necessarily apply to children under 3. So those of you who are listening who may have children that are under the age of 3, just know that the courts do have the discretion to modify your possession schedule based on what they think is in the best interest of that child in that particular situation. Well, Wanda, what do you mean by that? You have a number of children who are breastfed, which breastfed, depending on the judge you're in front of, they're like, you can pump. Is the baby eating table food? Okay, well, pump enough to go over to the other parent and they're still going to get their weekend, right? So some children have a lot of issues that go on with their, like their small and large intestines. So digesting food and milk may require a bit more of attention. So that could be a reason why a judge wouldn't be so quick to allow the child to go, well, the baby in this case, to go with the other parent for extended periods of time. Siblings, how far the parents live from one another, the environment in the other home versus the environment in the current home. Let's say you have a child who's extremely asthmatic, but in the other home, everybody smokes, or someone in there smokes and it's bad enough to flare up the asthma of the child. Those are some of the things that the judges look at. So with children under 3 specifically, they do certain schedules that stair step a parent up into this modified schedule I'm getting ready to talk to you all about. So beginning on September 1st, 2021, there's a modification. In Texas, prior to that, parents who lived within 100 miles apart had certain visitation, right? There is also parents who live over 100 miles apart who had certain visitation. Well, now it's 50 miles. That's a game changer. Why is that a game changer? So let me tell you why. Because you literally had parents that lived 10 miles from each other and they still had that first, third, and fifth weekend. So when you hear this non-custodial parent complaining, I want to see my child more. Why is it that we get a split schedule? That's not fair. We live so close together, right? I didn't think it was fair. Well, obviously, someone in the Texas legislature believed that there needed to be a change. So now in Texas, a child that's over 3, it is presumed to be in the child's best interest if the parents live no more than 50 miles apart that they have a split schedule. Split, y'all. Split. I will say that again. Parents that do not reside more than 50 miles of each other get to have a split schedule. To me, that's so dope. I mean, if the other parent lives 10 miles up the road, why shouldn't it be a split schedule? You know what I mean? And usually children that are 3 and 4 years old, they're not even in kindergarten yet. They may go to daycare or anything like that, but that's not anything where the curriculum is required for the child to be in school. So I think that's totally awesome that that child or those children have just as much access to the other parent as the parent that they may be living with primarily. So how does that look like, a split schedule? There's a variation. So some people think split is 1 full week with one parent, 1 full week with the other parent. That's not the only split schedule. You have what's known as 2-2-5. So let's say on Monday, Tuesday, the child is with one parent for those days. Wednesday, Thursday, they're with the next parent for those days. And then they rotate every weekend. So every 5 days, it changes. The holiday schedule changes. You usually see it where one parent has Christmas in the even year, the other one in the odd, and they rotate like that, rotate with spring break and everything like that. What do y'all think about that schedule? I mean, me personally, I think it's awesome. I encourage parents to want to have as much interaction and be around their child as much as possible, especially at that age. Just to give you all a little background about my situation, when I was in law school, when I started law school, my son was 2 years old. And I left him here in Dallas with my parents while I went off to law school in Houston. Do you know how hard it was for me to be away from my son? He's 2 years old. So I missed some of those milestones, right? And I knew that I was doing what was in his best interest. But as a parent, it made me feel bad. And still to this day, I have some regret about it, some guilt, because I feel like I missed out. But I constantly remind myself I did what was in his best interest. Because had I not made the decision to go do that, I wouldn't be able to take care of my son the way that I wanted to today. So why did I share that with you? Well, one, I want you to know something about me. If I'm asking you all to support me, support my show, and everything like that, and I'm opening up to you, giving you information, I think it's only right that you know a little bit more about me than, my role as Judge Bundabeat, or that I am running for family court judge. I think you should know some things about me. So that's something personal you all know about me. And trust me, as we keep getting to know each other, you'll find out a little bit more. But why did I give you all that story? Why did I share that with you? Because you have parents who are not even in situations remotely close to that, who want to be a part of their kids' life. and they're not able to do it primarily because the other parent says no. And that's just not fair. I believe that every parent should have equal access to their child given the appropriate circumstances. I understand, family violence occurs. I understand that sexual abuse occurs. I understand that there are situations where Child Protective Services, CPS, has to intervene. Absent a situation like that, a circumstance like that, let that other parent be a part of that child's life as much as they want to. They have the right to create these memories, just like you have the right to create these memories. Let them do so freely. Okay. So, you all got a little bit of background about why certain court orders look the way they do. We are going to dig deep. Trust me, this was just scratching the surface. Like I told you, I think it's good for you to have a basic understanding, because sometimes when you go in court and you really don't understand what's going on, you really don't understand some of the lingo that's used. A lot of people walk out feeling jaded. Not that some situations are not right, they're not fair in terms of the ruling, not saying that, but at least if you understand why certain things can happen, it gives you much more of a better understanding, and it helps you be a little bit more prepared for court. So the next time we meet, we're going to be getting ready to write down about temporary orders hearing. Like I got a hearing coming up, Vonda. I don't know what to do. I don't know who to ask to come. I don't know if the doctor needs to be there, what I need to do to get the doctor there. I'm gonna give y'all all of that information. And I had another attorney ask me, why was I doing this? Because they're like, you're doing this for free. You're not getting paid to do this. Well, I disagree. I don't believe I'm doing it for free, because as a Christian, I believe that it's my duty to give back information that may not necessarily be readily available to populations and people that can't afford to go hire somebody like me to give it to them. And quite frankly, it doesn't take food off my table giving it to you. So we good. This is y'all tuning in to me, getting the information is enough payment for me. So we're good. Any questions? Let's see. Do we have any questions I can entertain? And thank you guys so much. I see all the comments. I love you all back. Let's see. If I give my baby mama $500 for my baby, which is 3, do I have to pay more in child support? Jerome, no, you do not. And that is an excellent question. That is a misconception. People believe that, you know, when a child, if you're paying child support and a child has more activities and everything going on like that, they have a duty to do it. Should you do it? Maybe, depending on what it is. If you're in a financial situation where you can do it, then that's fine. But if you're not in a financial situation to give more, your child support is what it is. Sorry if that offends anybody, but it is what it is. After you pay child support, you're really not responsible in terms of required under law to do anything more than that. So thank you, Jerome. That was a very good question. Child support that's old, is it always old, even if the child is 32? Yes, that is also a great question. Thank you, CJ Rogers. Child support that is old is always old. That is known as retroactive child support. You'll also hear it named another way. I want to make sure you all know the appropriate terms so you don't get confused. Retroactive child support can also mean back pay. Okay. So when you hear someone they owe back pay, they're talking about retroactive child support, and you'll also hear arrears, ARREARS, arrears. All 3 of those things mean the same thing. It means that child support is still owed. At some point, someone fell behind, child support wasn't paid, and it is going back into collections essentially. So you are still responsible for that. And my encouragement to anybody who is in arrears is to get those things paid down as fast as possible. Why am I telling you that? Because the state of Texas has the Attorney General's office through the state of Texas has a child support division. They have an interest in the child support what do you call them? The cases. I'm sorry. So they're doing the monitoring. So they have an interest in it. So there is a 6% interest tagged on every month that those arrears are behind. So if you can get those paid down as quickly as you can. Do you have to go to court when they turn 18 to stop child support? Man, y'all have some great questions. Rapper J, absolutely. You have to, well, let me say this. You don't necessarily have to physically walk into court. What you have to do is to notify the Attorney General's office in Texas that the child has now turned 18. Now, this is tricky. You all listen carefully and write this down. Just because a child turns 18 does not mean you're done paying child support. It's 18 or they graduate from high school, whichever one happens later. So your child could turn 18 in February, but they don't graduate until June of that year. Guess what? You're paying child support, although they're 18, until they graduate through their graduation. So at that point, what you want to do is contact the Attorney General's office. And it's very simple. You can get their email address after you get someone on the phone, send them a copy of the diploma. Poof. It's that simple. But yeah, that's a great question. Thank you, Philip. Love your channel. Thank you so much. Here's a great question. Does the domestic violence have to be documented? Like, did we have to call the police and report it? That is an excellent question. Okay. That is an excellent question because no, it does not have to be documented. Everybody, and that's another reason I'm doing this. I want to clear up misconceptions. People think that if something isn't documented, it hasn't happened. That's not true. Testimonial evidence. When you raise your right hand and you swear to tell the truth, the whole truth, and nothing but the truth, you are affirming and acknowledging that everything you're getting ready to say is the truth. So until that is refuted by someone else saying it didn't happen and this is the reason why it didn't happen because I have a witness to say that it didn't happen like that, or I actually have a document to disprove what you're saying, your testimony is sufficient enough for evidence. So if you go in court and you say he or she has been violent with me for the past 2 years, these are the things that they did. If they don't really say that it didn't happen and try to make an excuse for why it happened or whatever the case may be, it happened. The judge is going to take that into consideration, and there's a likelihood that they may find that family violence has occurred. Thank you, Carly, for that question. Let's see. Good, I took my headphones off. I know, right? They were tripping. Let's see. If the child was born out of rape and they're 3 years old and it was never documented due to threats or fear, how do you prove it? Okay, this is a great question. Again, your testimony is evidence. So you, just by the nature of you saying it, we're accepting it as true, right? The court is accepting it as true because you raised your right hand and you sworn to tell the truth. Now the other person may say it didn't happen or something like that, but in that case where you're saying that something didn't happen, it would be in your best interest to have a document or a person or someone who was present to say that it didn't happen. Otherwise, the court more than likely would take that evidence and say that they take what you're saying as truth, and that's all the proof you really need just by speaking it. Thank you so much, V, for that question. Let's see. Do we have another question? Rapper J, do you have to still pay child support if your kid has a mental disorder? And if so, when do you stop paying? Now, this is an excellent question because, again, going back to what I said about a child being 18, you have to stop paying child support. Where if a child has mental needs that will go beyond the age of 18, there is a section of the family code that allows for a parent to pay child support beyond a child being 18. This is an adult child, right? So you do have that. I've seen court orders where people were ordered to pay child support indefinitely because the adult child, had so many issues. What are some examples of that? You have people that have cerebral palsy. They may be confined to a wheelchair. They may need a 24-hour nursing staff. I've seen it where people have been obese and the city had to come in and widen their doors and widen the toilet just to give them extra comfort, because they are obese. And this has in turn affected their immune system. It's affected their respiratory system that requires them to have around the clock nursing care. And even if they can live on their own, they have to go to the hospital and the doctor quite frequently. So in those cases, you can see people paid child support indefinitely. Maya Cunningham, did I skip? I'm sorry, I missed your love your hair. Is that the one you're referring to? Thank you so much. I appreciate it. If that's what you're referring to, I apologize. If I missed something else, please retype your question. I promise not intentionally trying to miss anyone's question. I want to make sure I get everyone's question. Do I have to continue to pay child support after my child turns 18 or 21, or when Medicaid stops, or do I need to pay in arrears? Now, this is a good question, and I hope I'm answering your question, Apple Pies. I love your name too. Apple Pies and French fries. Very cute. I like that. So, even after your child support obligation ends when the child turns 18 or graduates from high school, whichever one happens later, then that's where your child support obligation ends. However, if you owe arrears, your arrears are there until they are paid off. You will still owe them. Your child could be grown, have kids of their own, married, living in another state. If you have never paid those arrears off, they will still be there and you will still owe them. Okay. Did I get everybody? I just want to say I love watching your videos. I love the way you talk to the parents and how fair you try to be. I hope your campaign is going well. Sending love from NC. Thank you so much. I appreciate that. We have a question from Brittany Johnson. If you get married and you owe back child support, will your spouse be responsible to pay child support? Now, this is an excellent question because the Texas Family Code in the child support section speaks to this specifically. No, you do not owe back child. You do not have to pay back child support if your spouse is in arrears. Now, what I will tell you is this: if you all file taxes jointly, okay, and arrears is owed by your spouse, the Attorney General's office will intercept that entire refund that may be coming from the IRS. Now, they have when I say the IRS does have a form that you can fill out. I believe it's called injured spouse form or something like that, where you can request that your portion comes back to you. But generally speaking, if you all file jointly and arrears are owed, your tax return will be intercepted. Great question, Brittany Johnson. Stephen Harvey, can my child's mother get me served at the address we live at? Absolutely. A person can be served at any place at any time. In Texas, specifically, you cannot be served on Sunday. So you can't serve somebody on Sunday morning in church or anything like that. Now, if you have church on Saturday, and you just so happen to be in the pulpit, it's fair game. I actually seen somebody get served with child support papers while they were up there preaching on a Saturday. So yes, you can be served anywhere you can be found. How can you switch custody from mother to father if mother is neglecting her children? Alexandria Johnson, that is a great question. And that goes into what we were talking about earlier with joint managing conservatorship and sole managing conservatorship. That'll be more on the subject of a modification. But just to answer your question briefly, you have to have documentation. If the child is at least 12 years old in the state of Texas, a court must shall. It's not discretionary. They have to talk to their child. So if something like that is going on in terms of neglect and that child is at least the age of 12 and they're able to articulate that, then yes, the court can talk to them, hear those facts. And that's one way, if the court believes it's in the best interest of the child for the child to live with father, then you can flip custody that way. But tune back in, we will be going all through modifications because modifications is a lot of information to cover. Thank you for your question. Miss Maya Cunningham, can your child support increase because of needing help to pay for child care and daycare? This is an excellent question. The answer is it depends, right? So if it's been 3 years or something like that, in Texas, you can request a modification. And you can, not a modification, I'm sorry, you can request a review of the child support. But you have to show that circumstances have materially and substantially changed. So somebody normally wouldn't pay in, well, the Texas code, you can't order somebody to pay child support and daycare. What you would do is increase the child support, but you have to show that it has been a material and substantial change that warranted that cause to deviate from what their current child support is to something else. So if the circumstances with childcare and daycare existed at the time that the order was entered, you're not going to be able to prove a material and substantial change. Therefore, you wouldn't be able to increase their child support. Thank you for that question. That was a great question. What happens if someone works for money under the table or for cash only? How do you prove their income? This is an amazing question, and we're going to get all into that when we talk about child support. Matter of fact, when we do child support, we might have to just make it a full hour of me talking, question and answers, because that happens so often. But just the short answer for now, you have to be able to have documents on them. When I say documents, I'm talking about tax returns. If they file tax returns, if you can find some 1099s, if you can get bank statements. I'll also tell you all how to do discovery. Discovery, when attorneys do it, it's extremely expensive, but if you cannot afford an attorney and you have to represent yourself, I can walk you through how to do your own discovery because it has to be very specific. You have to know exactly what you're looking for. But there are definitely ways to get someone to pay child support that's not minimum wage based on documents if you can find those documents if they're self-employed or get paid under the table. Thank you, Caroline for that answer. I mean, for that question. Thanks from NC. It's a lot of people from NC in here. Step parent income. Can it be added to increase child support? No, it cannot. Step parent income is not applicable in the child support calculation at all. So you're good. What's the cap for child support in Texas when calculating income? Adam, Vernon, thank you for this question. It is $9,220 of net resources. So it caps there. If someone makes beyond that, so let's say someone makes $200,000, well, obviously their net resources are going to exceed 9,200. I said 220, 9,200. So even though it exceeds, it still caps at that 9,200. There are certain circumstances in Texas where you're allowed to deviate and increase someone's child support, what's called above the guidelines. But again, you have to show special circumstances to make that happen. Some of the most common situations where you see that is where you see someone who, like I said, makes a lot of money. More so common with professional athletes. You'll see that a lot with professional athletes. My granddaughter's father pays child support, but she doesn't get the total amount that is to be issued. Okay. How can my daughter go about getting the amount for my granddaughter that should be issued? Miss Wanda, thank you for your question. Okay, so let me just make sure that you all understand this. When someone is ordered to pay child support, it's a certain amount that's listed in the court order. However, if anything happens to their employment, so if they get laid off, they get terminated, their hours shift, anything like that, you can see a shift in the child support amount. That doesn't mean they're still not on the hook for child support. That just means something has taken place with their employment that has not allowed their full amount to come in. But rest assured, when they start working those full amount of hours again, or if they're the job that they were terminated from, they get another job, their money is going to collect, is collecting in arrears anyway. But they will, when I say they, I'm talking about the attorney general will make sure that that money is pulled out. So your granddaughter will at some point receive the full amount that she's supposed to receive. Thank you again, Miss Wanda, for your question. Can a father's child support increase if the child is autistic and have two kids with language disorder? Well, it depends. Based on your question, Lisbeth, and thank you very much for it. It sounds like this would be more so of a modification. Again, for a modification, which we're going to cover later, you have to show a material and substantial change since the time that the order was entered. If the language disorder and the child being autistic happened before the order, that's not a material and substantial change. However, if it occurred after the order, we would have to look and see like what is the care going to require for those children to determine whether or not child support should be increased. Can inheritance be included in child support payments? Absolutely. I actually had a client that this happened to. My client had an inheritance that was sitting in his bank account. Okay. The ex-wife knew about the inheritance. Well, when they divorced years back and then they went back later for a modification, well, ex-wife knew about this inheritance that was sitting in the bank. So the judge asked my client how much money did he have in the bank. My client told him. The judge deemed it as income. And you all have seen me do that on some of my episodes where I've deemed income. That is a thing in Texas. He deemed what was in my client's bank account as income and took the gross and net resources. What was in there was the gross and took the net resources from that and ordered his child support based on that. So, yes, you can be ordered to pay child support based on an inheritance. What if the mom passes and there is child support owed and the grandmother has the child? It's still due. Is still due. Arrears do not go away. The arrears are still due even after the custodial parent passes away. So just FYI. And if that is the case and there is a court order in place, I'm assuming it is because you said child support was previously owed. The person that's in possession of the child, which in this case would be grandmother, can file a modification and request that child support payments be reallocated to her since she's actually in care, custody, and control of the child. That way, those arrears can make sure the state can make sure those arrears are reallocated and going directly to grandmother for the child. So thank you, Ms. Breen, for your question. Stephen Harvey, I have two full-time jobs and my child's mother works part-time. Will my income be calculated on both jobs? This is an excellent question because it happens so often. No, it will not. However, with the change that has occurred with the possession schedule, I told you all earlier about the 50 miles. If we're looking at a situation where the custody arrangement is split, judges can take into consideration what that other parent makes. It's only right, right? Because if you have equal time, that means your expenses may not be equal in terms of what your electricity bill may cost or anything like that, but they're equal in the sense that those bills still exist in your home. You both have electricity bills. You both more than likely may have a car note, car insurance, mortgage, rent. So yeah, and no, in situations more so now with split schedules, yes, the courts can look at the other parent's income and they can choose to, depending on the circumstances, order no child support at all, or they can choose to offset it where they would take what mom's child support amount would be, what your child support amount would be, subtract the two, and whoever makes more. If you have two full-time jobs, if you're the person that make more, you would pay the difference between those two amounts. Thank you for that question. Let's see what else we have. I don't want to skip anybody. Do you have to pay child support if the kids get emancipated? Thank you for that question, Rapper J. We have another definition here. Emancipation. Emancipation means that a child is not necessarily at the age of 18, they could be 16. Emancipation means that the parents are signing off for this child to now be recognized as an adult. You have certain circumstances where that can happen. You may have a 16 or a 17-year-old who are deciding they want to get married. Parents can agree to emancipate them, going to the military, at 17, parents can agree to emancipate their child. So that's what emancipation means, guys. We're now recognizing, the state of Texas is now recognizing this human being who would technically be a child as an adult. Do you have to pay child support if the child emancipates? In a situation with emancipation, it really depends on the circumstance. So if this child is being emancipated because they're going to, let's say, attend college, right? You may have to still pay child support in a situation like that. It really depends. But I'm under the opinion that if parents are agreeing to emancipate a child, they may even agree to stop the child support. So it really just depends on the circumstance. Do you have to pay child support if the son or daughter is in college? This is a common misconception in Texas law. No, you do not. Only way you have to pay for college courses, pay child support when a child is taking college courses, is if that child is doing a dual program and they're still in high school taking those college courses. Then you would still be responsible for child support. Absent that, they're 21 and they're in college. No, it doesn't work like that. So, Rapper J, I answered your second question with that. So they'll basically believe the other person. How is one person's lying and not the other? Again, you got to have documentation to back up what the person's. If a person is claiming something against you and you're saying it's not true, you might want to have something to kind of back it up. Let's see. Let's say you don't have a job. How can you calculate child support? Well, the Texas Family Code has a specific portion that talks about people who do not have any income. They base it off of minimum wage. So the minimum wage in Texas, they take that, it's already done. So your gross is already done, your net is already done. Your child support usually is about $231. If you absolutely have zero income, you are in order to pay child support, you're more than likely going to pay around that rate based on minimum wage. In Texas, if step parent is carrying the child on insurance, but non-custodial lost their medical insurance, can the cost be reimbursed to custodial parent and step parent? Absolutely. Yes, that is how it works. They are reimbursed until that non-custodial parent who is responsible for that health insurance gets some more health insurance to cover the child. Then their reimbursement to the other parent stops. Let's say you don't have a job. How can you calculate how much you owe a month to the custodial parent for child support? That's what I just talked about. Apple pies and fries. I just love saying that name. That's what I just talked about with basing it on minimum wage. What if your ex-spouse supposed to pay alimony, but only pay child support? What will happen? So that's an enforcement issue, and we will get on that. I can assure you, you are going to learn a lot of ways to go about getting that money and getting that person to take care of it. I just don't want to jump into, well, in Texas, it's not alimony, it's actually known as spousal maintenance, but I don't want to jump into that now because it would take us off of what we're doing in terms of today's topic. But I can assure you, if you stay tuned, we will discuss it. My kid has bad ADHD and stutter. Does the father still have to pay after that? More than likely, yes, because ADHD and the stuttering situation, those are things that a child can necessarily live with, even if they have to take speech therapy or something like that. A court can take that into consideration while the child is under the age of 18, but beyond the age of 18, probably not, because a lot of people have they have, what do you have, productive lives, and some are even extremely successful that suffer from ADHD and a stuttering situation. What can a non-custodial need to do to gain more visits with the child if the other person refused to let the other the other person see the child. This again is enforcement, and we're going to get into that. But the short answer, what I'll tell you today is document, document, document. What do I mean by document? I mean every single time it happens, you write it down, you call the police, get a police report. Make sure you are following the order though. It's not enough to call the police or to go to court and say, "Dad, let me see my kid." You actually have to show the court, I showed up where the order said I'm supposed to be at the time I'm supposed to be there. They did not surrender the child. That's the short answer, but we'll get into the enforcement a little bit later. If one parent, Deanna, thank you. Thank you so much for tuning in. If one parent is ordered to pay child support but doesn't have money or a job, why can't the spouse's income be considered if it is only one person bringing in money? That is a great question. Unfortunately, I don't have the answer to that one. That's something with Texas legislation. They just do not they don't mention anything besides saying it can't happen. They don't mention anything, about a spouse's income being computed or anything like that. So I don't know when it comes to that. Someone asked, "Where's my tea?" I didn't want any tea today. It is a little cool outside, but I just needed some water because I knew I was going to be on here talking. So water is good for today. If the judge orders you to pay for college for the child and it's in the order, in Texas courts, that may happen in other jurisdictions. In Texas courts, a judge is not going to cannot order you to pay for college for a child because it's against the law doesn't, in order for judges to make certain rulings, they typically have to have some type of law in these books, right? That backs up their decision. That is not going to happen in a Texas court. Other jurisdictions, maybe, because I hear it. I hear it's quite common in places like Mississippi and Georgia, but that's not how it happens in Texas. Fire flame. Can the judge make you drop your medical insurance and have you pay the other parent? No, they cannot. Judges actually encourage a child to be double insured because at least if the child needs some sort of medical procedure that is not covered by one insurance fully, you'll have that secondary insurance that can kind of kick in. So you won't see a judge tell you not to do it. I got married at 15 and had a baby, and was emancipated by marriage. He was 25 years old. Oh, okay, okay. This is somebody, Miss Vita Worship, that's in the comments saying she was emancipated. That's neat. I never have actually met anyone who was emancipated. So thank you for sharing that with us. As a non-custodial parent who has had long-term possession of a child, what paperwork needs to be filed to be released from child support? Um, You've been in possession. So what you need to do is file a modification with the courts. And this in Texas, this is what you would do. Again, if you're outside the state of Texas, speak with an attorney in your jurisdiction. But if you're in Texas, you would need to file a modification to let the courts know that you have been in possession of the child. And if you are in arrears, you would also need some sort of custodial, what are they? Not custodial, possession credit, which means that if you've been in a possession, let's say 6 months, and your arrears previously were $8,000, well, you need that $8,000 to be credited towards your arrears since you've been in possession with the child. So make sure you file something in court for a modification. If you're not on insurance and they go to the hospital, does the other person have to pay it back if you pay? Absolutely. Uninsured medical in Texas is 50-50. Both parents are responsible for it. If one parent pays all, the other parent has a duty to send the other parent the entire bill, what they paid, so they'll need the receipt, and you need to look in your court order to see how much time that other parent is supposed to reimburse you. Let's see. Do I need proof of a bill if I want to modify child support? Can I just show up with an amount they're supposed to pay? You're in Pennsylvania. I'm not sure under Pennsylvania law. Like I said, you have to consult an attorney in Pennsylvania. But for anyone in Texas who has that question, do you need to show proof of a bill if you want to modify child support? If you're showing proof of bills like medical bills, educational bills, or something like that related to the child, yes, you would need to show that in court. Um, you're trying to gain more visitation. You want to see the child more. Oh, okay. Okay. If you want to see um the child more than what was court order, fire flame, if I'm getting your question right, if you want to see the child more than what's been court ordered, you still would have to petition the court on a modification and show what has materially and substantially changed that would warrant that particular change that you're wanting in your court order. A couple of you that have asked questions. I'm trying to get to someone who has not asked a question. I haven't answered a question yet. Shelley Whitford. I am the only active parent. Children's dad has gotten court postponed. And this happens quite often too. Just make sure that you're keeping documentation of everything. And when I say everything related to the children's expenses and everything like that, because if you do not have a court order in place right now, you can ask for back pay for not only child support, but for back pay for medical expenses as well. Thank you for your question, Miss Shelley. Let's see. Insurance. They did it, and that happened in Texas. And she had the non-custodial drop the insurance and had the mother put the insurance. Wow, that's interesting. I can say in Dallas County, I have never seen a judge order a parent drop insurance and force the other parent to do that. I've never seen that happen. I've seen a judge say you have to reimburse or you can get health insurance or whatnot, but that's interesting. I'm curious to know what county that was out of, if you don't mind sharing, Fireflame. Deanna, why do parents have to reimburse Medicaid and Medicare? They are both health insurance. It's one thing that parents don't have to pay. This is an excellent question. Simple answer. Medicaid is government assistance. So essentially, it has to be paid back. The state wants their money back. It's not free. And that's the misconception that people have when they get on Medicaid. They think that it's free. It's government assistance. It has to be paid back by somebody. The state is going to make the non-custodial parent pay it back. Let's see. I received a modification of $0. The custodial parent was a no-show. I mean, that definitely can happen. Depending on the circumstances, it can definitely happen. Is it possible that both parents have to pay child support if they have kids together and the children are split between parents? I guess I should say apple pies and fries. I have never seen that happen. I've seen both parents pay when neither of them have been in possession of the child and the child has been with someone else. But I haven't seen both parents pay in a situation where they have a split type of where the children are split. And quite honestly, I haven't seen a lot of situations where children were split between two parents. Those are very rare occurrences. I will say in Dallas County in particular, that's primarily where I practice. You don't really see a lot of judges wanting to split up siblings. Let's see. I have like a minute left, so let me see. Is there deadbeat parent laws? My son and dad keep going in and out of jail and hasn't reached out about their child in months, almost a year. No, unfortunately, there's not deadbeat parent laws. The laws are just there to say what should happen in the event that you need to get child support or something like that, but nothing specifically for deadbeat parents. What if mom takes the kid, gets surgery, and gives to dad until she is well? What if mom that has kids gets surgery and gives to dad until she is well? That's a temporary situation. So that wouldn't necessarily warrant a material and substantial change. And thank you for asking that question, because I will caution you guys from going into court based on temporary situations. Like if a parent say, hey, my roof caved in, can the child stay with you until the remodel? I get the house remodel, it's going to be about 3 months. I would caution you run into court to do things for temporary situations that you know are temporary, especially on a modification, because there is a portion of the family code that says if you brought a modification suit in bad faith, if that person hires an attorney to fight that case, guess what? You're on the hook for the attorney's fees. All right, guys, let me see. One last question. His siblings and himself spoke about him getting high on weed and laughing about it. In a situation like that where someone is using weed or any type of drugs around a child, you want to make sure you contact CPS, the police, whatever you have to do to protect those children. So, you guys, that was so much fun. That wraps up our first session. Just giving you a sneak peek into our second session. We're going to go ahead and we're still going to talk about conservatorship, possession, and access, but I want to go a little bit more into what these schedules actually look like when parents not only reside close to each other, but when they live a little further away from each other, and how that would, depending on your circumstance, how that would need to be presented at a temporary orders hearing. What is a temporary orders hearing? A temporary orders hearing is like a band-aid, right? So whatever you all have been doing that is the status quo, courts typically like to maintain that if it works or get you close to that. So it's a hearing that usually is no longer than 40 minutes total. Each party is given 20 minutes aside to present their case. That means in 20 minutes, you have to get all your evidence in, ask your questions on direct, ask your questions on cross-examination, and with your witnesses. So I'm going to show you all how to do that and get everything in that you need in those 20 minutes to prepare you for this temporary orders hearing. So again, make sure that you have your pen and paper ready. Looking at my calendar, we will go live again on, go ahead and write this down. We will go live again on Tuesday. That's next Tuesday, November the 16th at noon. And I'm not going to use these headphones. I'm just going to talk to you all like this. So again, next Tuesday, November the 16th at noon, 12 o'clock p.m., that's Central Standard Time. So make sure you all tune in. Thank you so much for your questions, for participating. You had some amazing questions. I hope I was able to answer most of them and give you a little bit more clarification. Before I leave, I did want to leave you all with those, what do you call it? The sections that you can go to and read up on the stuff that I talked about on your own. So if you Google Texas Family Code, chapter 153, chapter 153, that talks about conservatorship, possession, and access. So that way, everything that I discussed about conservatorship, joint managing conservatorship, sole managing conservatorship, excuse me, you're able to go read up on it yourself. Okay. Thank you, you all. I did, you know what? I did say, I misspoke. Who is that? Yvonne, thank you. I did misspeak. It's Tuesday, November the 9th. I'm not going to do you all like that and not come back for 2 weeks, right? Next Tuesday is November the 9th. November the 9th, 12 o'clock p.m. Central Standard Time. I correct myself. Thank you again, Miss Yvonne, for pointing that out. Next Tuesday, November the 9th at 12 o'clock p.m. Central Standard Time. I will see you all later. You all have a great rest of the week.